Tonight. Former political operative John Haggerty is out of jail after posting $250,000 in bail over the weekend. Haggerty was convicted of larceny charges on Friday for pocketing money from New York City Mayor Bloomberg. The mayor actually gave that money to the Independence Party for a ballot security operation back in 2009. Now, Haggerty is facing up to 15 years in prison. However, plans for an appeal are already underway. Here to discuss the case in depth is Haggerty's attorney, Dennis Vacco. Dennis, it is good to see you.
Hi, Liz. It's great to be with you again tonight.
So first, give us an update. My understanding is, as I mentioned, that John Haggerty is now no longer behind bars. He did post bail. It was a pretty considerable sum there, although less than we thought at one point it was going to be $500,000, which seemed awfully high. Was he a flight risk?
No, I don't think so. Unfortunately, on Friday after the jury returned its verdict, the prosecution made a motion for bail based upon their perception that Mr. Haggerty was in possession of an Irish passport,
right.
Really without much foundation other than some passing reference in an email. But that unfortunately then drove the discussion around post-verdict bail. The DA did ask Judge Swibel to post $500,000 or to set $500,000 cash bail to secure Mr. Haggerty's return to court. We were successful in getting the judge to cut that in half to $250,000 and to allow it to be posted either by cash or surety bond. And by early Saturday morning, late Friday evening, early Saturday morning, Mr. Haggerty was indeed released on bail.
Okay, so there's a couple of things going on here. In part, you know, this whole idea about whether or not he did have a passport or didn't have a passport. The judge seemed particularly concerned about the veracity of documents that he had provided. When he applied for a passport, he stated that an individual who used to be the New York City GOP chairman, I believe, was his uncle when he wasn't. I mean, were you aware of all this, and doesn't it make your defense of him going forward as an appeal more difficult?
No, quite frankly, it really, as I argued to the court on Friday afternoon, the passport application, or at least the reference that you speak to on the passport application, was immaterial. It was not only immaterial to the passport application itself, but it was certainly immaterial on the issue of whether or not Mr. Haggerty was going to return for sentencing at the appointed time. He does have a very close personal relationship with the individual who was identified on the document, and he listed that individual as an emergency contact. Right. And while there is no familial relationship, they are close enough that in my client's mind, this individual is a member of his family.
This whole thing seems to be very confusing. I mean, we saw, and I think viewers will recall on Friday, a report put together by our colleagues in New York One, and they spoke to some jurors who said things that were actually contradictory. One person said that they felt like the State Independence Party was an agent of the mayor's in receiving this $1 million that subsequently was given to John Haggerty, and another person, you know, had a different view of that entirely. I mean, the jury managed to come to a verdict at all that they all agreed on, I found a little bit surprising.
Well, perhaps that's one of the reasons, although I think there are others, that it took this jury almost 3 days of deliberations to arrive at a unanimous verdict. I did see the report that you speak of on New York One, where one juror suggested that the Independence Party was an agent of Michael Bloomberg. That was rather startling to me because we never argued consistently throughout this case from its inception. Did we ever argue that the contribution to the Independence Party was not appropriate? Quite frankly, our position was always the fact that the $1.2 million contribution that Michael Bloomberg made in 2009 was very much like the $1.2 million contribution that he had made a year earlier in 2008. It was a contribution to the Independence Party housekeeping account. Right. He lost control of it once the contribution was made, and the contribution was then the property of the Independence Party for them to use for any lawful purpose. The idea that the Independence Party would be an agent of Michael Bloomberg really cuts against the grain of the idea that the contribution was lawful, because a contribution of $1.2 million in the midst of a heated and contested mayoral race, if the Independence Party is truly the agent of Michael Bloomberg, then that contribution to the housekeeping account would seemingly be in violation of New York State's election law.
Tell me, Dennis, look, you've been in New York State politics for many years. You at one point were the state attorney general. You'd been candidate yourself. So you understand the difficulties and the strange vagaries of the election law, and specifically with fundraising. Do you think it's appropriate that this case has proven that housekeeping accounts are quite murky? Maybe we should do away with them altogether.
Well, Liz, there's a lot of things about this case that I think inform us about the way we fund campaigns in New York State. The housekeeping account is indeed a major loophole. It's a huge loophole in the law. If Michael Bloomberg were making a contribution to the Independence Party operating account, in other words, an account that they could use that money to support specific candidates, he would be limited by an annual cap. I think that annual cap is about $90,000 to a party committee, but more importantly is that an individual making contributions for the specific benefit of candidates, there's an annual cap of $150,000, which is not indexed. So that $150,000 annual cap per contributor has been in place for a long time. But yet the housekeeping account rules, and there's no question, I'm not saying that this loophole isn't legal, but it indeed is. It's a nuance in the law that allows an individual like Michael Bloomberg, who is extremely wealthy, to circumvent the caps on individual contributions by making a contribution to the housekeeping account, which has absolutely no limits. That's why we always said that the $1.2 million contribution was indeed lawful, but once it was made to the housekeeping account, because it could not be used for the benefit of specific candidates, Michael Bloomberg and his campaign lost total control of it. It doesn't make sense under New York State law to allow such an enormous contribution to be made and then to have the candidate be able to direct how that contribution is going to be employed on his behalf. So quite frankly, I believe that's against the law.
So it is clearly, actually, in New York State law, one of the more clear tenets, actually, is the one that you just stated, even though there's a lot of things that aren't quite clear at all and very opaque, actually. So what I'm hearing from you is that going to be the ground of your defense going forward, without you obviously giving away the store here and not in court?
Well, look at the next phase of this proceeding that we're focused on right now is the sentencing phase. Fortunately, the jury acquitted Mr. Haggerty of the grand larceny in the first degree, which carried with it a term of mandatory incarceration. So we're gratified that the jury understood our case to that extent, but he still faces the prospect under the grand larceny in the second degree of incarceration, although now it's not mandatory, it's discretionary. So our focus right now is on pulling together a sentencing memorandum, pulling together those individuals who are going to speak favorably on Mr. Haggerty's behalf, so we can make a logical and persuasive argument to the judge concerning the appropriate sentence in this case.
So he has not been charged with anything before, I believe, so might it also be easier then to argue that he should only get probation, for example?
Well, clearly he has a stellar record. He's worked for the comptroller of the state of New York. He's worked for the governor of the state of New York. He worked for me when I was Attorney General. He was a confidant of Michael Bloomberg, notwithstanding the mayor's assertions to the contrary in the witness stand. John's a highly respected individual within political circles on both sides of the aisle. I mean, the respect for John's ability and his political acumen is shared by both Democrats and Republicans alike. So it's our hope that we're going to be able to pull in a cross-section of individuals that are going to speak favorably to John, and certainly the fact that he has never been in trouble with the law before and has a clean record until this point in time is going to be a major feature of our presentation to the court.
And just remind us what date that is, that sentencing hearing?
Well, it was scheduled by Judge Swibel on Friday for November 4th, but that was at the time that he was also setting bail at $250,000. I did ask the judge for an extended period of time up to sentencing because we do want to take our time to carefully prepare our sentencing memorandum. So while it's technically November 4th, I do fully expect that we're going to get a continuance of that date, perhaps sometime into December.
Interesting. Okay. Well, obviously an ongoing case, a fascinating case, a little bit inside baseball, but I think speaks largely to the political process in New York and could change things going forward. So I want to thank you very much, Dennis Vacco, for being with us. It is good of you to be here.
Liz, it's a pleasure. Thanks for having me.
Hey, Dennis.